Hello everyone! It's been such a long time since my last upload, and I'm happy to find out that we are still growing continuously. Sa dami ng naghahanap, na-realize ko rin na wala pala tayong discussion about interpretation of contracts. And so, madali lang naman din to, might as well gawin na natin. Article 1370. If the terms of a contract are clear and leave no doubt upon the intention of the contracting parties, the literal meaning of its stipulations shall control. If the words appear to be contrary to the evident intention of the parties, the latter shall prevail over the former. So bakit nga ba kailangan pa ng interpretation of contracts? Bakit hindi na lang kung ano naman yung nasa kontrata as it is? Yun na yun. We just need to apply the terms in it. Mas madali, sana. Pero kasi nga, if only, kung sana lang yung mga words, terms, and conditions na nasa kontrata is so clear and explicit and ambiguous, kumbaga, na there is really no doubt regarding sa intention ng parties dahil malinaw lahat. So, if ganun, yun na yun. Yan yung applicable. I-apply the term as it is, di ba? It is to be understood literally just as they appear on the face of their contract. So, general rule, sabi ni Article 1370, if the terms of the contract are clear and leave no doubt upon the intention of the contracting parties, the literal meaning of its stipulations shall control. Kung yung terms nga ng kontrata ay malinaw at wala namang doubts, then yung literal na kahulugan mismo, yun na yun. But then, second paragraph says, if the words appear to be contrary to the evident intention of the parties, the latter shall prevail over the former. So kung merong conflict as to the words na nakasulat mismo sa kontrata and yung evident intention ng parties, sabi ni paragraph 2, yung evident intention ng parties ang magpi-prevail. So, general rule, again, with the terms of the contract are clear and unambiguous about the intention of the contracting parties, the literal meaning of its stipulation shall control. But if the words appear to contravene the evident intention of the parties, the latter shall prevail. In a way, it's best understood if meron tayong example. So, halimbawa, si Pogi, nag-deliver siya kay Ganda, okay? Pogi delivered to Ganda his parcel of land. And Ganda gave Pogi 1 million pesos. Na gumawa sila ng kontrata, of course. The title of their contract is Contract of Lease. Pero, sa document ng Contract of Lease na ginawa nila, merong nakasaad na for and in consideration of 1 million pesos. I hereby transfer the ownership of my parcel of land to Ganda. So, question, sa tingin nyo, clear and ambiguous yung terms ng contract nila? Di ba there is doubt as to ano ba talaga? Contract of lease ba, as indicated in the title, or sale ba? Kasi ba't ita-transfer ang ownership kay Ganda sa halagang 1 million pesos? So, applying Article 1370, if the words appear to contravene the evident intention of the parties, the latter shall prevail. Yung evident intention talaga nila, yun yung mag-prevail. So, ano ba ang gustong mangyari ng dalawa? Gusto lang ba talagang parentahan ni Pogi ang lupa niya kay Ganda? Di ba hindi? Kahit na ginawa nilang document ay contract of lease, pero may nakasaad doon na for and in consideration of 1 million pesos, I hereby transfer the ownership of my parcel of land to Ganda. Ang intention nila is to transfer ownership. And so, it is to be interpreted as a contract of sale, okay? It should be interpreted to mean a contract of sale because what they intend actually is to transfer the ownership of the land from Pogi to Ganda. Another example, they entered into a contract of lease pa rin. And Ganda would pay Pogi, say, 10,000 pesos as a rentals for a period of like 5 years. And at the end of the 5 years, Ganda would become the absolute owner of the property. Dito, applying Article 1370, This is actually contract of sale by installments. Kasi malinaw naman na yung intention talaga ng parties, kahit pa nakalagay sa kontrata, contract of lease. And kahit pa nakalagay doon, they are lessor and lessee, ganyan yung terms na ginamit nila. Pero makikita mo sa evident intention na iba ang gusto nilang mangyari. At the end of the 5 years, Ganda would become the absolute owner of the property. And so, yun yung magpe-prevail kung ano talaga ang gusto nila. Okay? So, that's Article 1370. Now, Article 1371. In order to judge the intention of the contracting parties, their contemporaneous and subsequent acts shall be principally considered. This provision simply provides that the acts of the parties shall be taken into consideration in interpreting the intention of the contracting parties. Kasi diba, papaano ba natin ma-judge ang intention ng parties? As we all know, intention involves a state of mind. And state of mind is really difficult to decipher. Paano mo malalaman anong nasa utak natin, di ba? And so sabi ni Article 1371, in order to judge the intention of the contracting parties, their contemporaneous and subsequent acts. Yung mga kasabay at mga kasunod na mga actions na mga ginawa ng parties should be taken into account. Yun yung sinasabi ni Article 1371. So, halimbawa, eto. Si Pogi and Ganda, nga, they entered into a contract. Hindi natin alam kung ano yung contract, but it involves a parcel of land. Now, after the execution ng contract, nakita ninyo, si Ganda, she already entered the property. Fenced it with, concrete fencing na talaga. Tapos, she began cultivating the land. And then, she also pays the real estate tax of the land for 10 years. All with the knowledge of Pogi. Okay? Lahat ng mga pinagagawa ni Ganda alam ni Pogi. So, malinaw, di ba, sa kanilang subsequent acts, giving consideration sa lahat ng ginawa ni Ganda, which is alam naman ni Pogi. So, dito malalaman natin na they both entered into a contract of sale. Actually, madali naman talaga itong interpretation of contracts. So, Article 1372. However general the terms of a contract may be, they shall not be understood to comprehend things that are distinct and cases that are different from those upon which the parties intended to agree. So what is the effect of the use of general terms? Ang sabi ni Article 1372, they shall not be understood to comprehend things that are distinct and cases that are different from those upon which the parties intended to agree. Kailangan pa bang i-explain to? It is very self-explanatory. Sinasabi lang naman, gaanong general terms man ang ginamit dyan sa kontrata, hindi dapat masasama dyan ang mga bagay na naiiba talaga. Okay? Halimbawa, nung binenta ni Pogi, etong bahay niya kay Ganda, may nakasaad doon sa contract nila, including all the furnitures therein. Okay, so lahat pala ng furnitures, including all pang ginamit ha. Pero sa loob ng bahay ni Pogi, mayroong makikita. Nara table belonging to Beauty. Washing machine, meron pang a 50-inch television set and a refrigerator. Question, saan dito o ano dito ang kasama sa nabili ni Ganda? So, isa-isahin natin. Remember, number 1, a Nara table belonging to Beauty. Remember that the table is not owned by Pogi. Kay Beauty to. So, meaning he cannot transfer ownership over that table. Hindi yan kasama malamang. And this washing machine, the TV set, and the refrigerator, these are not furnitures. Mga appliances yan. And ang sabi ni Article 1372, however general the terms of a contract may be, they shall not be understood to comprehend things that are distinct and cases that are different from those upon the parties intended to agree. So, di ba nga, ang word na ginamit is so general, including all the furnitures therein. All talaga. Pero furnitures naman. And so they cannot include things that are distinct from the parties intended. Iba ang furniture, iba ang appliances. Okay? So that's Article 1372. Now let's proceed with Article 1373. If some stipulation of any contract should admit of several meanings, it shall be understood as bearing that import which is most adequate to render it effectual. Tandaan lang, if one interpretation would make the contract valid and the other interpretation would make it illegal, yung una, yung interpretation which would make it valid and effectual would prevail. Okay? So, if si Pogi, binenta niya ang, yun nga, bahay niya kay Ganda. Now, Pogi owns 2 house pala. Meron siyang 2 bahay. Sana all si Pogi may 2 bahay, okay? One he owns exclusively, yung sa kanya talaga, and the other ay co-owner pala sila ni Beauty. Now, etong contract of sale ni Pogi and ni Ganda, walang consent ni Beauty ito, okay? So, ang question, saan sa 2 bahay ba ni Pogi ang binenta niya kay Ganda? Of course, sabi or applying Article 1373, it should be understood as bearing that import which is most adequate to render it effectual. Dito, exclusively owned ni Pogi, simply because this would validate the contract. Remember, yung contracts was without the consent of Beauty. So, medyo malabo pa yun. Dito na tayo sa exclusively owned ni Pogi. Kasi dito, meron talaga siyang kalayaan to dispose the property, yung bahay niya. That's it. That's Article 1373. Madali lang talaga. Okay? So, Article 1374. The various stipulations of a contract shall be interpreted together, attributing to the doubtful ones that sense which may result from all of them taken jointly. Sa mga provision ng isang kontrata, hindi mo naman talaga dapat basahin ng hiwa-hiwalay. You have to consider the entirety. Yung intention ng parties should be taken from the entire instrument and hindi lamang sa mga particular words, phrases, or clauses, kung ano man nandyan. Huwag mong isa-isahin. It should be taken as a whole and in relation to the other provisions ng contract. Okay? Pati yung mga contemporaneous and subsequent acts pa nga. So that is Article 1374. Article 1375. Word which may have different significations shall be understood in that which is most in keeping with the nature and object of the contract. Of course, words are to be interpreted in keeping with the nature and object and contracts. Kailangan mo talaga ano ba yung nature ng contracts na to, ano ba yung object ng contracts na to. Anyway, hindi siya ganun na provision. Let's proceed with 1376. The usage or customs of the place shall be borne in mind in the interpretation of ambiguities of a contract, and shall fill the omission of stipulations which are ordinarily established. Ito provides for a resort to usage or customs in aid of interpretations. So, example, if si Pogi nag-render siya ng services kung Ganda, halimbawa, yung bahay ni Ganda na sira, pinaayos niya kang Pogi at inayos naman ni Pogi. Now, dun sa agreement nila, hindi nila napag-usapan kung magkano ba ang ibabayad kay Pogi. In this case, the amount must be determined by the rate na customarily paid in the place kung saan render yung services. So, dito, magkano ba sa lugar nila ni Pogi at ni Ganda, magkano ba usually ang bayad? So, that's Article 1376. Let's proceed with Article 1377. Madali na lang tayo. Actually, patapos na tayo. The interpretation of obscure words or stipulation in the contract shall not favor the party who caused the obscurity. The party who draws up a contract in which obscure terms or clauses appear, kung sino man ang dahilan kung bakit nagkaroon ng hindi malinaw na terms dyan sa kontrata, he should be the one responsible for the obscurity or ambiguity. Dapat, di ba? So, the contract must or will be construed against him or strictly against him and in favor doon naman sa kabilang parties. Ito yung sinasabi ni Article 1377. And this is generally applied sa contracts ng insurance which are liberally construed in favor of the insured and strictly, dapat talaga strictly sana against the insurer para in order to resolve ambiguities in resolving ambiguities dito. Bakit? Why? Because almost all their provisions have been drafted by one party. Lahat na nag-prepare ng contract na yan, kung tutuusin, ay si insurer, di ba? The only participation of the other party ng insured is the signing of his signature or his adhesion. Alam, di ba, yung contract of insurance is and contract of take it or leave it. Gusto mo or ayaw mo. So, kung merong provisions or terms na hindi malinaw dyan, strictly against the insurer. Kasi nga, siya yung cause ng obscurity. Ito yung mga example ng contract of adhesion. Now, sa mga ganyang kontrata, kung mayroon mang provisions or terms na hindi malinaw dyan, is strictly against dun sa nag-prepare. In the contract of insurance, sa insurer. Kasi nga, siya yung nag-cause ng obscurity. Yun yung sinasabi ni Article 1377. Yung interpretation ng obscure words should not favor the party who caused the obscurity. Article 1378. When it is absolutely impossible to settle doubts by the rules established in the preceding article, and the doubts refer to incidental circumstances of a gratuitous contract, the least transmission of rights and interest shall prevail. If the contract is onerous, the doubt shall be settled in favor of the greatest reciprocity of interest. If the doubts are cast upon the principal object of the contract in such a way that it cannot be known what may have been the intention or will of the parties, the contract shall be null and void. So Article 1379 actually provides for a rule if magkakaroon ng doubt as to the incidental circumstances of the contract, and second, if there is also doubt as to the principal object ng kontrata. And so, if there is doubt that is actually or that are actually impossible to settle, and it refers to the incidental circumstance of a contract, we have to differentiate first if it is a gratuitous contract or one that is an onerous contract. If the contract in question is gratuitous, then yung rule as to the least transmission of rights and interest, yun yung i-apply natin. And if it involves onerous contract, then should there be doubts, then sabi it should be resolved in favor of the greatest reciprocity of interest. Okay? Pag gratuitous, apply natin yung least transmission of rights. If it involves onerous contract, yun naman greatest reciprocity of interest. Now, let's take an example. Halimbawa, ganito. If si Ganda, kailangan niya ng sasakyan kasi gusto niyang umalis. Okay? Gusto niyang magmuni-muni, hanapin ang kanyang sarili. And so, kailangan niya talaga ng sasakyan. Then, si Pogi, meron siyang sasakyan. Binigay niya kay Ganda ang susi at ang sasakyan. And then, Ganda used the car, drove the car, and then, umalis na. Dun sa kontrata nila, hindi naman malinaw kung ano ba yung nangyari. Walang pinag-usapan. Okay? Hindi matukoy if it is a donation or a comodatum, meaning loan. So, merong doubts. And it is actually impossible to settle kung ano ba talaga ang nasa kontrata nila. Okay? And so, if it involves gratuitous contract, kasi wala na naman binigay si Ganda kay Pogi, di siya nagbayad. The rule that is applicable would be the least transmission of rights and interest. So in this case, instead of considering that as a donation, i-consider natin siya as comodatum or a contract of loan lang. Bakit? Kasi ito ang magtatransmit ng lesser rights than a donation. Diba? Dahil dito, si Pogi pa rin naman, na-retain niya yung ownership. Kumbaga, pinahiram niya lang kay Ganda ang sasakyan instead of considering it as a donation kaagad. Kasi gratuitous, iba naman pag onerous contract. Halimbawa naman sa onerous contract is if si Pogi, nanghiram siya ng pera kay Ganda with 12% interest per annum.
Pero sa kontrata nila, hindi malinaw. Ano ba? Ilang buwan, ilang taon ba? 1 or 2 years ba ang period ng contract nila? So, in this case, applying Article 1378, the loan is presumed to be, yung mas mahaba, yung 2 years. Dahil, for this will favor the greatest reciprocity of interest. Wala namang problema. Kasi si Ganda, she can earn interest for a longer period of time. Tapos si Pogi naman, she can use the money in a longer term. So, mas favorable doon sa dalawa. Okay? Now, papaano naman if it is the principal object of the contract ang doubtful? Simple lang, kung doubtful talaga, if there is a doubt on the principal object of the contract, then the same shall be declared as void, okay? Under paragraph 2 of 1378. Kasi hindi talaga matukoy kung saan. And so, yun na lang. Halimbawa, eto. Si Pogi, binenta niya kang Ganda ang kanyang sasakyan. Hindi sinabi kung saan. Kumbaga, there is a doubt as to the object. Anong sasakyan ba ni Pogi ang binenta niya kay Ganda? Kasi meron pala siyang 3 sasakyan. Yes, maraming sasakyan si Pogi. Pero hindi talaga sinabi doon sa contract nila kung saan doon ang binenta niya kay Ganda. Ang tanong, which one is the object of the sale? The answer? The object cannot be, since the object cannot be determined, the contract is void. Malamang, kasi nga, yung principal object hindi mo ma-determine. Di ba? This is consistent with the rules, naman, sa contract. Di ba? Paano? Yung essential elements ng contract. Consent, object, at yung consideration. Hindi ma-determine kung saan ba doon, meaning walang object. Then, that is a void contract.
Article 1379. The principles of interpretation stated in Rule 1, 2, 3 of the Rules of Court shall likewise be observed in the construction of contracts. Daanan nyo na lang din, basahin nyo. Ano ba yung importante dito? Pareho lang naman, yung instrument should be construed as to give effect to all the provisions. Tapos, yung interpretations should be according to intention. And then, sinasabi din pala, tama, yung in case of words unprinted, kung magkaiba, partly written words and partly yung printed form, and these are inconsistent, hindi sila magkatugma, ang sabi, yung written words ang controlling. Ano pa ba? That's it. That's Article 1379. So, tapos na natin interpretation of contracts. Thank you for watching and for listening until dito talaga sa 1379. I hope nakatulong. And see you again next time. Bye-bye!